about another situation in Weinstein where another company tried to, I guess, ride on Michael's coattails. There's a different kind of participation agreement in the Weinstein case. So the one that Michael talked about, the Cohn case, was where you had the talent, the actors, the writers, the producers, who performed their services and then were entitled to profit participations in the relevant films. The next situation, which we'll call Y-Movie, because that's what the company was called, involved investment companies. And it was a very straightforward situation. You've got these investment companies, who again are called Y-Movie, who made these investments in certain films. In exchange for the investments, the debtors agreed to share a certain percentage of the film's future profits. So the next slide just sort of shows you exactly how it works. Again, not very complicated. And the key here is that the investments were completed pre-petition. So Y-Movie paid the money to the debtors pre-petition, and the obligation to pay the profit percentage had not yet happened at the time of the bankruptcy. So here, the posture was that the sale closed, and post-sale, Y-Movie sent a letter to Lantern, the buyer, and said, "Where's our profit percentage?" And Lantern said, "What are you talking about? We did not purchase your contracts." And I use the term purchase on purpose here because, as opposed to Michael's situation where there was a dispute whether the agreements were executory or non-executory, here there was no dispute. Everybody conceded that the agreements were non-executory. The investments were made pre-petition. That was completely over. The only thing left to do was for the investment companies to sit back and get their profit percentage down the line. In any event, Y-Movie, having been politely declined when they sought their profit participation, filed a motion to confirm that Lantern did in fact purchase their agreements. The arguments were frankly very convoluted and based on the asset purchase agreement and the related notices, very intricate. They tried to essentially catch Lantern sort of in a web of its own notices, arguing that the definitions of assumed contracts and title rights and purchased assets and excluded contracts and included and assumed liabilities all combined to result in the investment agreements having been purchased by the buyer. Lantern obviously opposed that motion to confirm, largely again on the basis of the operation of the relevant agreements. Lantern argued the investment agreements were not purchased. The totality of the documentation required that result. Lantern also argued that the investment agreements could not possibly have been assumed and assigned because assumption and assignment, as Michael started with, only applies to the Section 365 context where you're dealing with an executory contract. And here nobody argued that this was an executory contract. The judge ruled in favor of Lantern. The judge denied the motion to compel the assumption of those agreements or the purchase of those agreements. Now, Y-Movie's attorneys tried to compare the situation to the Cohn case and said that, look, we're not talking about pre-petition obligations. We're just saying that going forward, you need to honor these profit participations. And the judge observed that in the Cohn case, Lantern had conceded these were executory. I'm sorry, Lantern had conceded that it purchased the relevant agreements. I'm trying to help you.
They wanted to claim the ongoing benefit of these agreements.
I'm doing my best. Whereas here it argued that it had not purchased the relevant agreements, and the judge concluded that there really was no benefit to Lantern to purchasing these agreements, and there was no reason for them to have done so, and that in fact the agreements were not purchased. As far as practice notes goes, the court here appeared to double down on its analysis of executory or non-executory. The analysis really was very dependent on the terms of the agreement. The one thing I would note is that all the litigation in the Y-Movie context happened post-sale. And I would just quickly compare it to a situation in the Open Road bankruptcy case, where my firm served as debtors counsel. We had a similar situation with a company called Endgame, represented by our fearless leader, Nick Koffroth's firm. Endgame was a print and advertising financing company. They provided print and advertising financing to the debtors pre-petition, and among other things, part of the deal was that they would get a profit participation going forward. In that case, Endgame got involved very early on, filed multiple objections and reservations of rights, including a 43-page objection to the sale, well before the sale hearing. The arguments were essentially that the financing obligations and their financing agreements were part of one integrated agreement with the film distribution agreements, notwithstanding that there were multiple agreements and multiple parties involved, and therefore under California law and under the principles of cum honore, if the buyer wanted to get rights in the underlying films, the buyer also had to take assumption and assignment of the endgame agreements and be required to not only pay the go-forward amounts, but also pay pre-petition cure amounts. Wasn't litigated, the issue was settled, so we don't have a court finding the other way on this one. With that, I will turn it to Ted.
So, as happens with these usually, we have way more material than we have time for. So I think, at a very sort of 30,000 foot level, one of the powers, we've been talking about assumption and assignment thus far. The other flip side for executory contracts is rejection. And what is the impact of rejection of an executory contract? So David touched on this briefly where he said rejection of a contract is breach of the agreement, and it is not a rescission. It doesn't have the whole agreement go up on smoke. That very issue is actually currently before the United States Supreme Court. It's been fully briefed, and we're just awaiting a decision, which will probably come out this summer. It's in the trademark context, but it's in a case called Tempnology. There is another feature of that case, which is not part of the Supreme Court discussion because the court didn't take cert of the issue, but it was the impact on a distribution agreement of 365N. So when a debtor rejects an intellectual property license,
in which it's the licensor.
In which it is the licensor. So it owns the IP, it licenses it to a third party. If they choose to reject that agreement, Congress adopted 365N of the Bankruptcy Code, which allows the licensee to continue to use the intellectual property. It frees the debtor of ongoing obligations, but the licensee is allowed to continue using the intellectual property. They have to waive their set-off rights, and they can enforce exclusivity provisions as well as any extension options under the license. So far, so good. In Tempnology, the agreement had various components. It had a trademark license component. Trademarks are excluded from the definition of intellectual property under the Bankruptcy Code. So that's the issue that has traveled all the way up to the Supreme Court, which I'm not really going to talk about for purposes of this. But part of that agreement was also an exclusive right to sell patented products. So clearly a exclusive right to monetize patent rights. And the court looked at that and they said, that is not an intellectual property license. It is not protected by 365N. So analogize this to a film distribution agreement. Having the intellectual property or a license of the intellectual property is not really the most valuable thing. The valuable thing is the exclusive right to distribute the film and to monetize the distribution of the film. And under this case, I think there's a very real potential argument that a debtor could file for bankruptcy, reject its distribution deals, and the distributors would not be able to get the benefit of Section 365N.